Authority General Counsel. And today we're going to be talking about the private plan process. We are recording, so we will be able to share this recording with you. It will also be posted on our website, on our events page, on the link to today's webinar on today's date. I will also make available the slide deck that we are presenting, so that will be available to you as well. What I will go ahead and do is share my screen so we can get to the slide deck. As I'm doing this, let me just give you a couple of housekeeping rules. If you have questions, please put the questions in the Q&A function so that I will be able to go through the questions after I finish presenting on the slide deck. While I'm sharing my screen, it's difficult for me to respond to the questions right away. Please don't use the chat function because it's harder to keep track of the questions and make sure we've addressed them all in the chat. It's much easier to keep track of them in the Q&A function. So that's the one we'd like you to use. As I mentioned, we will be sharing the slide deck with you, so that is available to you. All right. As we go forward, just make sure that you can see my screen, and we will jump forward and talk about the private plans. Before we get into the thing, let me tell you a little bit about myself. As I said, I'm the General Counsel for the Paid Leave Authority. I have been working for the authority directly for over a year, but actually it was help work to create the authority in my previous role at the Department of Administrative Services. But by training, I'm an employment lawyer and have worked both in private sector and for the government as an employment lawyer for over 20 years. So the Connecticut Paid Leave Authority is a relatively new quasi-public agency, which means we are a state entity with a governmental purpose. But we are not a traditional state agency. We have a little bit more flexibility to operate our responsibilities as a quasi. And the goal of creating the Connecticut Paid Leave Authority was to create an organization that would enable employees who need to take time off from work to care for themselves or a loved one to have access to income replacement while they're out on leave. And we also think it's an important part of our mission to make sure that employers, administrators, and healthcare providers, really everyone who's involved in the leave process, understand their roles and responsibilities. At the Paid Leave Authority, we have many functions, including administering claims for paid leave benefits. And to do that, we have been collecting contributions for a year now. And so those contributions from employees go into the trust fund, the Paid Leave Trust Fund, and we use that money to pay the employees' benefits. And we have to establish all the policies and procedures necessary so that we have a fair and consistent way of handling all of our work. And we do a great deal of outreach and educational opportunities to make sure people understand their rights and responsibilities. One other function, what we're going to talk about today, is the private plan function. Under the statute, employers who are covered by the Connecticut Paid Leave law can fulfill their obligations under the law by offering their employees a private plan rather than having their employees remit contributions to the authority and come to the authority for income replacement benefits. And so in order to make sure that those private plans meet the requirements of the statute and that they are performing as promised, the authority is responsible for approving applications to offer a private plan and auditing those approved private plans. Just a quick overview about the paid leave program, just so that we're all kind of on the same page. The paid leave program requires employees who are working for covered employers in Connecticut to contribute 0.5% to that paid leave trust, unless the employer gets permission to offer a private plan. If the employer has permission to offer a private plan, the employees do not contribute any money to the paid leave authority. They may contribute the same amount to the private plan, or the employer may decide that the employees don't need to contribute anything. But unless there is approval for a private plan, the employees are required to contribute their 0.5% to the authority. The funds come from the employees, but the employer is responsible for the processing of taking the deduction from the paycheck and remitting it to the authority on a quarterly basis. Employees who are covered under the Connecticut Paid Leave Program are able to apply to the Paid Leave Authority for income replacement benefits if they meet our eligibility requirements. And we're the ones who assess eligibility. That's not an employer responsibility. To be eligible for paid leave benefits through the authority, the employee must have earned at least $2,325 in their highest earning quarter when you look at the first 4 of the 5 most recently completed quarters. They also have to be currently employed by a covered employer, or if they're not currently employed by a covered employer, they had to have been employed by a covered employer at some point in the 12 weeks before they apply to us for leave. And of course, you have to have a qualifying reason. You can't just apply to us for benefits if it's not a qualifying reason. Employees who work for an employer with an approved plan will apply to their employer for those income replacement benefits instead of applying to us. The first question is, am I a covered employer? If I'm not a covered employer, I have no obligations under the paid leave program. My employees don't get any benefits under the paid leave program, and they don't contribute to the paid leave program. So that's always the first question. The answer is almost all employers who have 1 or more people working in Connecticut are covered. So nonprofits are covered. Private sector employers with unionized workforces are covered. Small companies, large companies, whether they're headquartered in Connecticut or not, if they have anyone working in Connecticut, they're going to be covered. The state of Connecticut is a covered employer, as to our non-union employees. So managers, appointed officials, legislators, judges, we're all by statute considered to be covered public employees, and so the state is covered from that perspective. There are certain employers who are not covered by our statute, first of which is the federal government, because the state can't tell the federal government what to do. Municipalities and local or regional boards of education are not covered unless their unionized employees collectively bargain to participate. And if that happens, then all of their employees, union and non-union, would be considered covered. Non-public elementary or secondary schools are not covered either. That means they don't participate in the Connecticut Paid Leave Program. There are some other statutes so those are the first 4 are the ones that our statute specifically lists as not covered employers. There's a few other laws that come into play, including the Amtrak Act. So railroads are not covered employers because there's a federal law which says the railroads are covered by that federal law instead. Similarly, governments of other states, so the University of Massachusetts, for example, is a state entity of Massachusetts. So an employee who works there would be covered by Massachusetts, and they're not covered in Connecticut. Other sovereign nations, so the Mashantuckets and the Mohegan are sovereign entities, and they are not subject to Connecticut law, so they are not covered employers. If you're not a covered employer, you have no obligations under the Paid Leave Act. Your employees don't apply for benefits. And you certainly don't need a private plan because you're sort of already out of the circle. If you are a covered employer, that's who we're talking about today. The people who want an alternative to having their employees participate in the Connecticut Paid Leave Authorities program. Let's try and get this thing moving. If you want an alternative to participating in the Connecticut Paid Leave program, you can apply to us for a private plan. We do get questions asking how can we be exempted from the Connecticut Paid Leave program, and this is it. You can't simply opt out. You have to comply with the obligations through a private plan. And our statute allows for it as long as the plan is as good as or better than the benefits that we provide. If there's an approved private plan, the employer is going to be responsible for administering the claims for paid leave benefits. And the employer, once they're approved, will no longer have to remit employee contributions to the authority. The statute allows employers to take up to that same 0.5% from the employee's wages for the purpose of administering that approved private plan. If they do so, they must use the money only for the purposes of administering the private plan. They cannot use it for any other purpose, and they cannot take more than the 0.5% that would otherwise be required under our program. So it cannot cost the employees any more to participate in a private plan. There are two things that could be a private plan. One is an insurance policy. If you go the insurance policy route, you have to have a policy that's been approved by the CID, which is the Connecticut Insurance Department, from an insurer who's been approved by the Connecticut Insurance Department. If you purchase an insurance policy, it has to be a specific Connecticut paid family medical leave policy, a short-term disability policy or workers' comp policy or anything of the sort would not qualify. It actually has to be an approved Connecticut paid leave policy in the form that is consistent with the requirements established by the insurance department and the paid leave authority. And so if you do that route, the insurance company administers your claims for benefits. The other way you could have a private plan is to have a self-insured plan. So you as the employer are responsible for paying the benefits. Self-insured plans can come in two flavors. One is a self-insured plan that is administered by a third party, or a self-insured plan that is administered by the employer itself. Either way, if you go with the self-insured plan option, it needs to be supported by a surety bond. The surety bond has to be equivalent to a year's worth of estimated contributions from your employees, and it has to run to the benefit of the paid leave authority. That's to provide protection to your employees, that make sure that if everything fails and the private plan cannot fulfill its obligations, the employees still have protection, because the surety bond will give the authority a year's worth of contributions, and the employee can come to the authority for protection. The Connecticut Paid Leave Program has adopted a private plan policy and procedures document, which can be found on our website. If you go to www.ctpaidleave.org and click on the button that says, I want to apply for a private plan, you'll see all of the information about the requirements for a private plan and the steps for it. And then you can scroll down to the bottom and you'll see both the surety bond form as well as the private plan policy, which has all of the policies and procedures. Now, this is our second version. We had adopted an original version of our policies and procedures last year, and our board recently adopted a revised version, which provides a lot more detail to employers about how to go through this process and what the requirements are for the insurance policies. As I mentioned, in order to be considered, it has to offer the same or better benefits as the public plan. So it has to provide income replacement benefits at the same rate as our plan. It has to provide the benefits for all of the same reasons as our plan and for the same length of time. Short-term disability policies that you may have will not qualify. Typically, a short-term disability policy would cover an employee for their own serious health condition, and possibly for bonding with a baby, but they don't provide coverage for other types of caregiver leave or other types of military family leave or family violence leave. And many short-term disability policies do not provide benefits for the same length of time or the same amount of coverage. As you mentioned, the policy cannot cost the employees more than the public plan. It could cost less. So if you want to provide this as a complete benefit to your employees, you don't have to make the employees contribute toward it. But if you are going to have them contribute, it can't be more than the 0.5% that they would otherwise have contributed to the authority. Your private plan must cover all of the employees that you have working in Connecticut. So if you're a multi-state or multinational, it doesn't have to cover your employees who are in, Ohio or Germany or wherever, but all of the employees working here in Connecticut have to be covered by that private plan. You cannot have a plan that covers simply the executive suite and then tell your manufacturing team that they have to participate in the public options. It's all or nothing. And the statute specifically requires that the private plan must be approved by a majority vote of the employees working here in Connecticut, the people who would be covered. So even if you would normally expect that benefits are the management's prerogative to decide on, in this situation, by statute, you have to let your employees know what your proposed plan is going to be and hold a vote to make sure that they are in favor of moving into a private plan. Again, the paid leave authority is entirely employee funded and it exists for the benefit of the employees. So they're the ones who have the ultimate choice as to whether they want to be in the public program or be in a private program. There are a number of insurers who have been approved to offer Connecticut paid leave insurance coverage. And the Connecticut Insurance Department is continuing to receive applications all the time. So if you have an insurer who's not on this list, they're not precluded from applying. They simply haven't done so yet. The Standard Insurance and MetLife are highlighted on this list because they are the only two of the insurers who have taken the second step, which is actually receiving approval for their insurance policy. All of the others are still working to develop their insurance policy forms to comply with the latest requirements. So you can still get coverage from them, but they haven't done that second step yet. So what does this process look like? Well, the process itself is really short, but there's a lot of work you need to do before you apply. So let's start there. As I mentioned, you can either have an insurance policy or a self-insured policy. So that's the first question. Which do you want? Do you want an insurance policy, in which case you need to work with one of those insurers I just listed, or you can develop a self-insured plan based on the self-insured plan template that the authority has created that you can find in our private plan policies and procedures document on our website. You need to educate your employees about your proposed plan. And to do that, we've created what we call a plain language guide, which is a template that you can modify that gives your employees information about what you intend to do. Will you make them contribute? If not, you need to say so. If you're going to make them contribute, is it to the 0.5% or is it something less? Are you going to require your employees to use their accruals, their vacation or PTO, other PTO, before they access the benefits under your policy? Who can they contact at your employer or at the insurer or your administrator with questions? So the plain language guide template is available, again, part of that policy document on our website, but you need to modify it to the specifics of your particular company. And you need to give that plain language guide to your employees together with your proposed self-insured plan or your insurance policy document so that your employees can understand what they're going to be voting on, why they should vote for your private plan versus stay with the Connecticut Paid Leave Program. You have to give them at least 2 weeks to review those documents, and then you hold a vote. The vote has to be anonymous. And just to be clear, when we say anonymous, we mean that management can't know how the employees voted. We recommend using, if you're small enough and it's easy for you, you could use the good old-fashioned secret ballot with paper ballots. If that's administratively difficult, given your size or given the sort of remoteness of your workforce, there are all sorts of online apps for voting options like SurveyMonkey or Google Docs. Email is not a great option because with email, you know who's voting in what way, and that is the opposite of an anonymity. There's one exception to the anonymity requirement, and that is if you only have 1 or 2 employees working here in Connecticut, you know who they are. There's no way of really being anonymous, and so we do have an exception for that one situation. A majority of the employees working in Connecticut must vote in favor of the plan. So if you have 100 employees working here in Connecticut, at least 51 have to vote affirmatively in favor of the plan. If you have 100 employees working in Connecticut and 60 of them don't vote, they don't respond to your survey or they don't submit their paper ballot, the plan is going to be denied. It's a majority of the potential workers, not the majority of workers who voted. And as I mentioned, if there's a self-insured plan, you need to obtain that surety bond that has to run in favor of the authority. It has to be equal to the estimated value of the year's worth of contributions to your employees. The surety bond form that we accept is on our website, and that's the form you have to use. The surety bond company has to be someone who's got who's rated with the federal government. So we're not particularly strict about who the surety bond company has to be, but it does have to be someone who's reliable enough that they received a treasury bond rating or treasury rating from the federal government. The surety bond is only required for self-insured plans. So once you've done all of those preliminary steps, the application process should take less than 10 minutes. You would go to your account on ctpleave.org. By this point in time, you should all have an account on ctpleave.org because that's what you would have been doing. You had to create that account in order to be remitting the contributions that you've been paying for the past year. So you go to your account and you click on the particular business name. If you have multiple businesses, you would click on each one individually because you have to apply for each business. And then you would just click on the private plan tab and follow the instructions. You will be prompted to upload your plan document and the plain language guide, as well as the surety bond. And you'll be asked specific information about if it's an insured plan, who the insurance is. You'll be asked about how you handled the vote. You know, was it a secret ballot? Was it an online app? And you'll have to provide the information of how the voting turned out. Again, each company has to have its own application and its own vote. So if you're an organization that has multiple related entities all under an umbrella, but each entity has its own FEIN number, then each entity must apply separately, and the vote must account for just the employees of that particular entity. I don't want, because we connect compliance based on FEIN number, you don't want to have one FEIN number that has approval for a plan, but your 6 other entities are sort of out there in limbo because they're not associated with a private plan and they haven't been doing contributions. So you need one application per FEIN, one vote for FEIN, and the information should be per FEIN. When you apply, you're going to attest that you will be complying with the private plan requirements, and if you have an insurer or third-party administrator, that you will direct your insurer to do the same. As the employer, it's your responsibility, and the insurer or TPA is simply your agent. There will be some reporting requirements. We'll need to hear back from employers about how many plans they've or how many claims they've approved, and so you're attesting that you will comply with those requirements. Again, just a quick reminder about the plain language guide. The purpose of it is to explain to your employees what your plan offers, and the template can be found at Exhibit B to our policies and procedures. You can add to the plain language guide if you want to explain to your employees why you're providing better benefits. But your changes have to be accurate and complete and non-coercive. So this needs to be a free vote by your employees. They can't be forced into or feel like they're being forced into voting for a private plan because the employer has indicated that if they don't, they'll suffer consequences. Again, the employee vote has to occur after you've given your employees their plain language guide and their plan documentation. You can give that plain language guide and the other plan documentation to the employees in whatever way that you are giving your employees other legally required postings. So if everybody in your worksite is on email, you can send it to them by email. If your traditional method is to mail it to their houses, you can go ahead and do that. You need to make sure that all of the employees in Connecticut have the opportunity to review those documents. And that means that even your employees who happen to be out on leave right now have to have an opportunity to receive those documents. So if you have employees who are out on leave and therefore don't have access to email, you may have to send it to them separately. All of the employees must be given the opportunity to vote, including the employees out on leave. As I mentioned, the vote must be anonymous in the sense of management can't see what the employees are doing. We've had people say, well, the other workers don't know how I voted, but everybody in the corner suite knows. Then it's not anonymous. And it can't be that you got everybody in a room and tell them to put their heads down and put their hands up, because that's not capable of independent after the fact verification. We've given you the question. It's really easy and clear. Do you approve the private plan to provide benefits required under the Paid Leave Act? Yes or no? The full list of requirements is in our policies, private plan policies and procedures document, which again can be found on our website. When can you apply for benefits? Well, we accept applications on a rolling basis, so you can apply at any time. However, the approvals are only occurring, the approvals will take effect on a quarterly basis. This past year, because we were in the pre-claim phase, we did allow employers to apply, and if they got their application in by the end of a quarter, they were approved for that particular quarter, and so they were excused from remitting contributions for that quarter. That was something we did to just make it easier for employers to apply in this year. But as of November 1st, that changed. And so now there's sort of no more retroactive approval of applications. Now the applications must be approved no later than 30 calendar days before the end of the quarter, before the quarter in which the approval takes effect. What does that mean? Well, it means that in order for a plan to have been approved to take effect on January 1st, 2022, you would have had to get your application in and have it approved no later than December 1st, 2021. We're now past December 1st, 2021, so applications that are coming in now, if they get approved, will be approved to take effect as of April 1st, 2022. So application comes in today, I approve it today, the employer is still, and the employees are still covered by the Connecticut Paid Leave Program through the first quarter of 2022. They will remit their contributions for all of 2021, as well as the first quarter of 2022. If they apply after March 1st of 2022, then the approvals will take effect in June, and so on and so forth. We need to do it this way because we're now accepting claims for benefits. And so we can't simultaneously be processing a claim for benefit for someone who's currently covered under our program and then retroactively approving a private plan and saying, okay, well, you didn't get approved until the end of the quarter, but we're going to make it effective as of January 1st when we're already processing claims for January 1st. So that's why we had to make this prospective only. There have been plans that have been approved in 2021. We did it provisionally because we still had to work through the requirements for the insurance policies. Any plan that received provisional approval in 2021, they are continuing to be approved as long as they continue to offer the proposed plan to their employees, that they still have it in effect. We have two processes, one for fully insured plans and the other for self-insured plans. For the self-insured plans, if they received approval for their self-insured plan, we wrote to all of those entities. We notified them that they had to upload their self-insured plan document. The deadline for uploading that self-insured plan document, which is based on the template we created, was December 15th. We have heard from some companies that needed an extension of time, and we are granting that. But the goal is to make sure that the self-insured plan documents are uploaded into the application, and these employers are receiving final approval. They also need to make sure that they keep their surety bonds in effect. For the fully insured plans, it's a little bit dependent upon when the insurance companies receive approval from the insurance department for their insurance policy form documents. So for MetLife and Standard, they've received the approval. MetLife and Standard are now reaching out to their clients and saying, we've received approval, we're issuing you an actual insurance policy that includes a face sheet that has sort of specific information about that particular employer. Employers covered by those entities must upload the face sheet. All of the other insurers that received provisional approval are in the process of submitting their policy forms to insurance department. And so they are, a few days behind in terms of when they will issue their policies to their clients and when their clients will have to upload their insurance policy document to us. So if you've been approved in your self-insured, you've already gotten emails from us. If you are a self-insured plan that doesn't think they got an email from us, check your spam folder because it's probably there. And if you're a fully insured plan, we are writing to you as we learn of approvals. So messages to MetLife and Standard customers are going out this week, and we'll send out messages to the others as we get approval from the insurance department. For entities who have not yet received approval, you don't have to worry about the things I just talked about. You would just apply as I described using the final documents. Approvals are effective for 3 years. From the date that we notify you that your plan has been approved, or until the employer changes its private plan. So if you have a private plan that's been approved by the authority after a vote from your employees and you want to change it, say you want to change your insurance carrier, or you want to change the contribution because you originally were going to cover the contributions and now you want the employees to contribute, you would have to reapply. So your existing one is in effect unchanged, but if you want to make a change, you'd have to go through the whole approval process, including getting a vote from your employees for your new one. If you change it without letting us know, then certain penalties may occur because that becomes a early termination of the plan. So you really don't want to make any changes without going through the application process. As you mentioned, for self-insured plans, they update their surety bonds on a yearly basis. So the plan is approved for 3 years, but the surety bond gets updated for the next year's estimated contributions. We can deny or we can withdraw approval for a private plan if the employer has engaged in any of the behaviors listed on this slide. And these are the behaviors that are listed in the statute. So threatening or coercing your employees in connection with a vote, failing to pay benefits timely in a manner consistent with public plan, failing to maintain the surety bond, misusing the private plan funds, failing to submit reports as required, providing false information to the authority or insurance department, failing to comply with the requirements of the Paid Leave Act. Since you're standing in our shoes, you have to comply with the same statutes we do, or directing your insurer or third-party administrator to engage in such actions. In the event that let me go back one page. In the event that we believe any of these actions have occurred, we will go through due process before we do a withdrawal of approval, giving you notice that this is what we believe occurred and giving you an opportunity to let us know that it didn't occur. But it's important, again, to make sure that the employees remain covered either through the private plan or through the authority. So we need to have the ability to say, hey, private plan, you're not doing what you're supposed to do. Going through a lot of information. Again, a lot of our information is on our website. If you have questions that aren't answered on the website, you can certainly submit them to us using our Contact Us portal. But before you do that, you may want to check out our frequently asked questions or videos on the website, particularly the videos about how to register or how to apply. with that, let me stop sharing my screen. I see 2 questions have come in, so let me see what those questions are. And if you have any other questions while I'm looking at this, please feel free to add them to the Q&A. So yeah, if an employee is offered short-term disability, would they be eligible for Connecticut paid leave? And then similar question, if the employee is exhausted FMLA and short-term disability, can they get CTP leave? So I'll answer both of these questions. Let me point out, before I answer them though, that a short-term disability policy is not going to be approved as an equivalent to the Connecticut paid leave program. So you can't just say, oh, I have a short-term disability policy, please approve as a private plan employer. Many employers do continue to offer short-term disability as an additional benefit, even though they're in the Connecticut paid leave program or in a private plan. And that's fine. It can be an extra benefit. The statute says that an employee can receive benefits from the paid leave program and the employer concurrently, as long as the total amount does not exceed 100% of their regular wages. So in the paid leave program, what we're doing is asking the employer, do you offer any sort of income replacement to your employee, either through PTO or short-term disability policy? And if so, are you requiring the employee to use that first? So they're the primary employer, primary payer, or are they going to be the secondary payer so that the authority issues its benefits first and the benefits offered by the employer simply top off or supplement those benefits? And either way is fine. It's just that the employee can't receive more than 100%. For private plan employers, they could do the same thing. They could say, we're a private plan employer, we're offering Connecticut paid leave program, paid leave act benefits, but before you access your private plan, we're going to require you to use your accruals, or we're going to require you to access your short-term disability, or we'll use the accruals or short-term to top off. The private plan can do the same thing. The second question is, all right, say you've exhausted your FMLA and short-term disability, would you still be eligible for CTPL? So I think we need to clarify some terms here first. FMLA is the Family Medical Leave Act. There's a Connecticut one and a federal one. They provide job protected leave. That's what they do. The leave essentially is unpaid unless the employer chooses to offer some sort of benefits, like short-term disability, or to require the employee to use their accruals. But the statutory entitlement is unpaid job protection. If you offer short-term disability, that just gives the employee money while they're out on that unpaid job protected leave. Connecticut paid leave, similarly, only offers income replacement. It doesn't offer job protection. So just setting the stage. An employee could be eligible for Connecticut FMLA for job protection and apply to the paid leave authority or the employer's private plan for income replacement benefits while they're out. It's also possible an employee is not eligible for Connecticut FMLA or federal FMLA, or that they've already used up their FMLA entitlements, but they still need to be out because they have a serious health condition and they need to care for a family member. They may not have job protection, but they can't work, and they could apply to us for benefits or to the private plan employer for benefits. So I hope that answers your questions. Let me tell you that we also do have webinars that we offer that get into the details of actually how the Connecticut paid leave program works and what the covered reasons are and how the benefits are done. And we talk more about kind of the covered reasons and how FMLA interacts. So if you're interested in knowing that piece of it, as opposed to kind of the private plan side that we're talking about today, please check out our events calendar. We have dozens of, we've done hundreds of webinars, honestly. We've had a lot of them, but we have more scheduled, and we're actually building our calendar of events for the next few months. So, there will continue to be webinars available. And you can also go to YouTube and just type in Connecticut paid leave, and you can see the recordings from past webinars. So that may be helpful if you're looking for more of that nitty-gritty about the paid leave program and interaction with FMLA. Another question came in, which is really kind of that nitty-gritty stuff. If someone is out now, does the FMLA clock start over on 1/1/22 and they get 12 new weeks? The answer depends on a couple of things. If you were already subject to Connecticut FMLA before 1/1/22, so you were an employer in Connecticut with 75 or more employees, and your employee was out on Connecticut FMLA leave, the Connecticut Department of Labor has said that you can basically take that time into consideration. So if they go out again in 2022, you look back 12 months and see, did they take any leave under Connecticut FMLA in the past 12 months? And you would deduct that from their 12-week entitlement. So that ability to deduct the leave is only available if you were already subject to Connecticut FMLA. If you were not already subject to Connecticut FMLA because you were not an employer in Connecticut with 75 or more employees, which is the old rule, but you are a Connecticut employer with 1 or more employee, which is the new rule, then your employees get 12 weeks starting 1/1/22 for a qualifying reason. Even if you were kind enough to give them entitlements before, you can't count that against their new entitlement. Great. Just take a moment to see if anyone has any additional questions that they would like to present. Again, this really is focused on the private plan option. So I would ask you, if you have questions that you think of later, to go to our website, ctpaidleave.org, and click on the tab for private plans. And that gives you access to the list of insurers who offer private Connecticut paid leave private plans. It gives you access to the Connecticut paid leave private plan policy and procedures document, which lists all of the requirements. It also includes the template for the plain language guide, as well as the template for the self-insurance plan. If you have questions about how to apply, you can always submit questions to us through our Contact Us. And if you have more questions about just paid leave in general or how it interacts with FMLA, I encourage you to check out our other webinars. As I said, we have many scheduled and dozens upon dozens on YouTube if you want to check out old ones. Thank you very much for your time today. It looks like we've answered all the questions and none more is coming in, so I'll give everyone 15 minutes back to their afternoon.